Puerto Rico has been winning the race to the bottom. Now, the U.S. and other wealthy countries want to call off the race. Act 20 and Act 22 to the rescue. Welcome to Taking Shelter. I'm your host, Peter Palsen. I recently recorded a video on global efforts to knock out tax havens and how that effort could harm the economy of Puerto Rico. Tax incentives are critical to the economy of Puerto Rico. Not just Act 20 and Act 22, but provisions designed to bring employment from some of the largest companies in the world, as well as on a smaller scale, incentives to keep critical medical services and other specialized services in Puerto Rico, given the constant outflow of people, skilled workers, to the mainland. The race to the bottom is a term used by Janet Yellen and other officials to support the global minimum tax efforts I discussed in my Statehood video. Basically, the idea is to have every company pay a tax of not less than 15% or 21% or whatever the agreed rate is, regardless of where they do business. The idea is that the home country tops up the tax if the local rate is less than the target. How does Puerto Rico's collected tax rate compare to these target rates? The U.S. IRS recently issued a summary of information it collects from large U.S. companies about their global footprints. Based on the latest available data, these big U.S. companies reported having 73,000 jobs in Puerto Rico and paying tax at an effective rate of 1.6% on their Puerto Rican income. If you toss out island nations that don't have any income taxes, like Cayman Islands or Bermuda, Puerto Rico is the clear winner of the race to the bottom. Many low-tax countries around the world are concerned about the impact of the global minimum tax push. Specifically, at different points in the discussion, Ireland has suggested that they could lose somewhere between 10 and 50% of their foreign investment as a result of these developments. And they have a 12.5% tax rate, which is 8 times higher than Puerto Rico's collected effective tax rate based on that IRS survey. So as I said in my statehood video, Puerto Rico has a reason to be concerned. What about the countries that don't have taxes, like the Cayman Islands or other so-called treasure islands? Al Jazeera News recently published an article that suggested that those countries are more reliant on individual high net worth investors and less reliant on big business jobs. The conclusion of the article is that these investment-related regimes can better protect an economy from the global minimum tax fallout. Puerto Rico also has investment-related tax incentive regimes. That would be Act 20 and Act 22, which have now both been folded into Act 60. Yes, Act 20 is technically a business provision, but in the minimum tax context, it functions more as an individual investor provision. So Act 20 and Act 22 may take on a greater importance to the Puerto Rican economy, but they first need to survive 4 challenges. Number 1, IRS enforcement efforts. Number 2, legislative changes in Puerto Rico. Number 3, legislative changes in the U.S. And number 4, statehood, the prospects of statehood. I'll talk about each of these challenges and why I think Act 20 and 22 can and should survive. First off, IRS enforcement activity. I think most everyone with an Act 20 or Act 22 contract knows that the IRS is on the scene in Puerto Rico. I have a video on the Act 22 IRS campaign, so you can check that out on this channel. In that video, I note that something similar happened in the case of the United States Virgin Islands around 2005, and that some of that controversy is still ongoing. Essentially, this is routine enforcement activity, but it won't feel routine if it is directed at you personally. Most people I speak with about moving to Puerto Rico have never been audited. To these people, I say that an IRS examination is a formal process, and you have formal rights, and you should understand those rights and be prepared. There are many interesting issues beyond bona fide residence, particularly in the Act 20 space, and I expect there will be a lot of controversy and litigation. It is worth a separate video at the appropriate time. Some people might view the IRS activity as a threat to Act 20 and 22. I don't see it that way. At a policy level, the IRS does not make or change tax law. They enforce what is on the books. Consider that after 15 years of focused IRS enforcement in the United States Virgin Islands, the investment tax incentives of the USVI are still in place, as are the U.S. tax exemptions for bona fide residents of the USVI. Item 2, legislative change in Puerto Rico. Around the start of this year, there was a bill introduced in the Puerto Rican Congress to repeal Act 20 and Act 22. It does not appear to have broad support, and to me, it is a head-scratcher. Between the annual fees and Act 20 taxes and other payments, I believe these provisions boost the Puerto Rican economy by at least $100 million per year without a meaningful direct cost to Puerto Rico. You have got to really hate kids driving around in golf carts in Dorado to turn your back on that kind of money. The current government is on record defending the incentives. Earlier this year, Chuck Schumer suggested in a recorded Zoom call that the Act 60 incentives were BS, and he used the full term. He said, "You don't let the wealthy get an escape route to not pay taxes." In response to these comments, the Puerto Rican government replied that Puerto Rico has the right to use local tax incentives to promote economic development. The Secretary of the Treasury of Puerto Rico also defended the program. I would thus be surprised if Puerto Rico would choose to eliminate the incentives in the short term. In fact, I would go the other direction. If it makes sense that investment incentives will become increasingly important to island economies, then it makes sense for Puerto Rico to consider expanding and improving Act 20 and Act 22, and there are a number of ways in which it can be improved. The programs are nearly 10 years old, and significant changes in U.S. tax law have occurred in that time frame. Thus, rather than eliminate the incentives, it makes more sense to me to expand them and to better align them to current U.S. tax rules. Item 3, the prospects of legislative change in the United States. I have a video on the mechanics of Act 20 and Act 22 incentives and their interaction with U.S. tax law. You need both sides to work to create the maximum incentive. The major cog of U.S. tax law in this area is Internal Revenue Code Section 933. That allows bona fide residents of Puerto Rico to exempt their Puerto Rico source income from U.S. tax. Section 933 applies to 3 million bona fide residents of Puerto Rico and has been around for most of their lifetimes. If you eliminate Section 933, you'll require all 3 million Puerto Rican residents to top up their income to U.S. tax rates. That would create chaos. Plus, at a high level, it seems premature to consider eliminating Section 933 before the statehood issue is resolved. There are some ways that U.S. tax law could be changed to target people who use Act 20 and Act 22 incentives. I feel like even this is unlikely for a number of reasons that take too long to discuss. Bottom line, if the government of Puerto Rico is defending the benefit of these incentives, I feel it is unlikely that Congress will try to eliminate them through the back door. Someone might point out that the 3 million residents of Puerto Rico don't vote in U.S. elections. That is true, but there are double that many people of Puerto Rican descent in the U.S. Puerto Ricanos de los Estados Unidos. Puerto Rican descendants are the largest group of Hispanic voters in Florida, and there are more people of Puerto Rican descent in New York than there are residents of San Juan, Puerto Rico. This is an important constituency in U.S. politics and would logically be a deterrent to any action that could be viewed as harming the economy of Puerto Rico. Item 4, possible statehood. I want to make it clear that I do not have an abuela in this fight. I appreciate that statehood is a provocative topic with impassioned people on both sides. In fact, YouTube or someone took down a comment on my statehood video that suggested that statehood could be a good thing for the people of Puerto Rico. As I said in that earlier video, I am not sufficiently informed to get into all the pros and cons of statehood. However, even informed people have different views on major issues like, number one, how many alternatives are there with respect to statehood, and two, the significance, what is the significance of the various referendums that have occurred in Puerto Rico over a number of years. In 1981, the U.S. Government Accounting Office issued a report titled Puerto Rico's Political Future, a divisive issue with many dimensions. The report discusses the many U.S. government programs that would need to change or at least be addressed in connection with a consideration of Puerto Rico statehood. The situation has not become more clear in the last 40 years. To sum it up, as I said in my earlier video, I feel that any impacts of statehood on Act 20 and 22 are many years away. Bottom line, I don't see any of these pressures negatively impacting Act 20 and Act 22 incentives in the short term. In fact, I think they could get better. I don't rule out the possibility of Puerto Rico continuing to marginally tighten up the requirements and increase the costs as they have done in recent years. And if I'm wrong and Act 20 and 22 go away, keep in mind the words of a great pirate. If it suddenly ended tomorrow, I could somehow adjust to the fall. Good times and riches and sons of bitches, I've seen more than I can recall. This has been Taking Shelter. I'm your host, Peter Palsen.